You're listening to Black Parents Aging, where we help you navigate caring for aging loved ones. Every Wednesday, we'll discuss how to help your parents successfully navigate this new season of life. We are going to talk about legal, health, technology, and finances. Here's your host attorneys, Olivia Smith and Nicola Robinson.
Hello, and welcome back to another episode of Black Parents Aging. We are coming off of the Thanksgiving holiday in 2020. I do not know when you're listening to this, but we are still in the middle of the COVID-19 pandemic, and we are seeing the numbers rise. And that is the reason for today's episode. We don't want anything to happen to you, and we certainly don't want anything to happen to your parents. But with the COVID pandemic, we need to be prepared, y'all. We need to know if there was a medical emergency, who will be making the decisions and what type of decisions will they have to make? So that is going to be the topic of today's episode. I'm putting on my lawyer hat. I'm going to give y'all the tea on some legal documents today. I'm going to try to make this brief, and I'm going to try to keep it in plain and simple language. I am not going to fill this with a whole lot of legalese. But today, I am talking about the Advanced Directive for Healthcare. That is what it's called here where I am in Georgia. Every state has a document like this, so you just need to research what is the document called in your state. This is the document that names someone that can step in your shoes and make healthcare decisions for you in the event there was a medical emergency or you had to get in the hospital for whatever reason. So this is a document that you need and your parents need. So I'm giving you all the information so you can share this with your parents and so that you can go out and get your own document created. So I'm going to give you just a little bit of the agenda for today. We're going to talk about the purpose of the document. We're going to talk about the difference between this document and like HIPAA release, because we always fill those out. We're going to talk about the difference between this document and another important medical document, a do not resuscitate order. So sit back. I'm going to get real deep on this one. Okay. So the purpose of the Advanced Directive for Healthcare, again, that's only what Georgia calls it. Your state may call it something different. Your state may even still call it a living will. Georgia got rid of that term in 2007. So if your parents are here in Georgia and they're still talking about, oh, I already got a living will, that is a red flag, y'all. That document is 13 years old. It's probably time for them to update it and take a look at it and see if everything in the document still works for them. In your state, it might be still a living will, and that's okay, as long as it covers the things that we're talking about today. So like I said, the purpose of the document is give someone the ability to step in your shoes and to make healthcare decisions for you. So you can get specific medical treatment based on the decisions of the person that steps in your shoes. And we call that person the agent. I like to call it your healthcare helper because it's just easier for you to remember. An agent is a very loaded legal term sometimes. So your person, your healthcare helper, can refuse medical treatments on your behalf. They can advocate for medical treatments on your behalf. So you want to name someone to be that medical decision maker before there is ever a crisis, when this person is able to really have a conversation and go deep with you on what your desires are if there was an emergency. You want to pick somebody who really, really knows you, who you feel very strongly will actually carry out what it is that you would want. So, okay, who can be your healthcare agent? Must be somebody of sound mind. If you know it's somebody that is really emotional, does not make good decisions, gets stressed out easy, they probably, while you may love them to pieces, they may not be the best person to serve in this capacity. And they must be over the age of 18. You also just want to think about who can serve in the sense that who's around me, who's somebody that I talk to every day. You don't want to pick somebody that may necessarily live overseas or it's just they don't come around that often because they live far away. So these are things you want to keep in mind as you're trying to figure out who can be your medical helper. Before I even get deep into the parts of the document, the difference between your Advanced Healthcare Directive and your HIPAA release. The HIPAA is a Healthcare Information Portability and Accountability Act release. That's a mouthful. But just think of this way. HIPAA is the document that you are signing or that your parents are signing that is a one-way street. It is just giving your doctors and your healthcare providers the ability to share your medical information orally or in writing with those people you've identified in the release. So they can share it for three reasons: for payment, for treatment. So they're probably going to be sharing with other doctors, or for the purpose of an operation. This is not a medical decision making instrument. So you can share all your medical information with a bunch of people. You can share it with your family, your cousins, your sorority sisters, your in-laws. It doesn't matter. It's just they are sharing the information. They are not expecting these people to use that information for anything besides treatment, payment, and operation. And like I said, treatment and operation is usually sharing that information with other healthcare providers. And then payment is who's going to foot the bill for this. But when you need someone to make an actual healthcare decision based on the information that's shared, that's when your Advanced Directive for Healthcare kicks in, because that's where you've named the person that now needs to be the decision maker. So there's 4 parts to the document. There is the first part where you name your agent. Then there is the second part where you talk about what your treatment preferences will be in certain scenarios. So I'll talk about that in a little bit. Then there's a third part where you need a guardian. I'm going to say, what's a guardian? I get that question all the time. So I'm going to that. And then there's the fourth part where you do the signatures. So naming your agent. Like I said, that agent must be 18. They cannot be your treating physician. And they can't be a person that witnesses and signs the document. So the document, once you fill it out, has a part where you need 2 signatures. So it can't be one of those 2 people that signed the document. And usually the witness can't be one of the people that work. You can only have one person that works at the medical facility where you're getting treatment. So just be mindful of that. Your witnesses need to be over 18, not your treating physician, and only one of your witnesses can work where you're getting actual treatment. You want to make sure your agent is someone that knows you very well, someone that lives in close proximity, because we may not have the time to wait on them to travel to then come and make decisions on your behalf. And you want to also pick an agent that's willing to do this and is able to do this. I get in my office people all the time that's like, well, I just pick my oldest daughter, or I'm just going to, pick my uncle or whatever. Yeah, but have you talked to them about this? This is the hardest part, y'all. If you have not talked to that person, you may not know whether they're willing to serve in this capacity. Because think about it. This is when stuff has gone really, really wrong, and we are really faced with life or death. And if it's a person that just doesn't want the pressure of that, which is kind of understandable. I mean, we have no idea what kind of predicament we might be in. But if you know that they are not strong of mind and able to make decisions under pressure, that might not be somebody that you want to name as your agent. You also want to make sure it's somebody that's going to honor your wishes. If you feel very strongly that you just want nature to take its course, you may not want to pick your daughter, or you may not want to pick your cousin, or you may not want to pick your auntie who's going to be like, fight, fight, fight. Because then we have an issue. They are not honoring your wishes. So when you're talking to your parents about this, have a real deep conversation about, well, mom and dad, who do you feel is going to honor your wishes? And when you are filling out your own healthcare directive, which I highly, highly recommend, you want to make sure you name somebody in your document that's going to also honor your wishes. And you want to make sure the person that you pick is just emotionally and mentally mature. And I think that kind of goes back to what I was just saying. If they are not able to really advocate, step up to the plate in the middle of this crisis, then that's probably not going to be the right person. I could tell you from my own life, there are certain people who I know love me to pieces, would never name them as my healthcare agent. And it's not because of any love or any shade. It's just because I know in a medical crisis, they are not probably going to be the ones to go in there and say, okay, doctor, I need a second opinion. Okay, I need to understand what this means. You want to pick somebody that is going to be calm in a crisis, that's going to understand what's going on in terms of medical prognosis, medical diagnosis, and all the terms that the doctors might be throwing at them. You want to have somebody that's not afraid to speak up, that's like, wait, I don't understand. I need to ask more questions. Somebody that's going to say, you know what, this facility is not doing everything that we think they should be doing, and ask for you to be transferred. So you want to make sure that your agent is also your advocate. This is a person that's like, I don't care what the doctors are saying. I need to have all the information before I make that kind of a decision. So, then what can your medical helper, also known as your agent, do? They can ride in an ambulance with you. They can sign documents on your behalf. They can negotiate and enter into contracts and agreements on your behalf, which is really, really important. Again, that goes back to making sure you pick the right person, because you want to make sure this is somebody that is working in your best interest. They're not just out here willy nilly signing things on your behalf. You want to make sure that this person understands this role 100% and is just okay with it and is able to do it. Your medical helper can admit or get you discharged from a facility. So think about if you had to go into hospice or you had to go into long term care. They can examine your medical records. They can consent to or authorize some types of medical procedures, just like they can consent to withdrawing medical procedure treatment or any type of programs. And then here in Georgia, we also just have a very blanketed, they can act in any way that is reasonably necessary in terms of your medical treatment. Let me also be clear. Under this document, this is a document that only comes into effect when we have come down to a very serious medical situation. This is not the document that the doctors are going to look to if your mama fell and broke her hip. They're not looking for your medical agent if you're getting tonsils removed or if you're just in the hospital for some type of routine treatment. I get that question all the time because people feel like they're giving up a lot of power, and that's not what it is. This is only when we have come to a place where the doctors are not sure what the treatment needs to be and things are looking really grim. This is not when there is just routine medical procedures happening. Okay. So please make sure you share that with your parents, because that is a lot of the fear that I hear in my older clients and what causes them to not want to necessarily execute the document, because they don't want to give up power and they don't want to give up control over their own autonomy in their body. And that's not what this is about. So make sure they understand that. Now, what can't your agent do? Just like you gave them all these powers, you need to understand that the agent cannot approve psychosurgery. They can't mess with your mental health or any type of medical illness. They can't make any kinds of decisions when it is a situation of addiction. And they cannot make any decisions in terms of sterilization treatments, which, I mean, let's be honest, we all can understand why these make sense. So, a lot of times I get this one. Well, I don't really need this because my spouse don't make these decisions. Or, my parents are both still alive. So I just know my dad gonna make the decision for my mom, or my mom gonna make the decision for my dad. And so you just kind of leave it up to chance, or you don't put a document in place. I get that. Happens all the time. Even if you have parents who are still married and still able to make decisions for one another, you want to talk to them about the importance of having this document. Because what happens is if they haven't had that conversation about, hey, in a medical emergency, here's how I want you to handle it. Now your family is just kind of guessing. Your dad is trying to guess what your mom would want to have happened, and vice versa. That is a heavy burden on any family member because now you have them wondering, am I making the right decision? Am I doing what you would want? You know, it may come down to a situation of it's time to pull the plug. Your dad is going to have to live with that decision, or your mom is going to have to live with that decision. And so there's a lot of feeling of guilt that comes with it. And there is also, y'all, you've seen medical bills. Y'all are not clueless to the fact that medical is expensive. And so if you are having to kind of work through all of this in your head and taking on time, medical bills are still running up. And the family could be sitting for a while just trying to figure out what it is mom would have wanted. And then what happens when y'all disagree? We see that all the time. Dad wants to go ahead and pull the plug, and that's where he feels is best for mom, but you may not feel that way. So now y'all are fighting. And the longer y'all are fighting about it, the more the medical bills are continuing to run up. I'm going to give y'all a quick story about a lawsuit that happened probably in the 90s. So, depending on how old you are, you may or may not remember this, but this came out in New York. So, I want to say it was in probably the early 90s. There was a woman, she went to the hospital and she ended up being in a vegetative state. So, she was in a coma with no hope for recovery. Her husband and her daughter was just like, okay, remove the feeding tube, let nature take its course. We understand where we are. Well, the nursing home and the doctors disagreed. And since she hadn't put anything in place, the family now had to like fight with the medical facility. So the husband and the daughter, while they were on the same page, they had to take the doctors and the nursing home to court to seek court order as to what could happen. Now, mind you, this man and his wife had been married for 36 years. The children were all grown. They all had testified in court to listen, we know that this is what our mother would want. She would not want to be hooked up to these tubes and everything. And guess what? The court denied it and said, nope, we're going to side with the doctors and the nursing home facility. So then the husband had to appeal the court decision and end up having to go to a higher court, which eventually the higher court did agree with the husband and the daughter. Well, it took 2 years for them to fight this out in court. And so they ended up spending, I think, if I remember correctly, they spent like 4 years going back and forth with the doctors in court about whether they could pull the tubes. That was expensive, y'all. You're talking about 4 years of her now getting medical treatment that the family did not want. And then the legal fees of having to fight it out in court. And guess who had to pay all that? Her family. And this all happened because she had never written this down. So just think about that. Her husband was there and could make decisions. Her daughter was there and could make decisions. But then the doctor said no. So you don't want that for your family. You don't want a situation where everybody's kind of looking at each other like, okay, well, this is what we think she wants. When you could just very well write this down. And then the doctors have no choice but to honor that. So here in Georgia, we have a hierarchy, if you will. If people don't write this down, let's say you do not heed my advice and you still just say, okay, well, we'll figure it out. In Georgia, the priority is doctors have to go with anything that you put in this document. So this document allows you to be your number one advocate because you get to name your medical treatment preferences in the document. So in this situation about the family I was just discussing, had mom written it down that she just wanted nature to take its course, they would have had no choice but to honor that here in Georgia. Second, The document says, in our laws here in Georgia, anybody that's named in the document has high priority as to who can make a decision on your behalf. Then, if there is no document, we look to spouses to make that decision for each other. Then we say, okay, if there's no spouse, a parent for their child. I'm married. I know that my husband would be the person to make that decision. But what if he wasn't around? Then it goes to my parents. I absolutely would not want my mother to make this decision. And so if I don't write that down, then it goes to her and my father to have to figure it out. Well, my parents are divorced. So which one of them would have to make that important medical decision on my behalf? So you see how quickly, if you just leave it to, okay, well, your next of kin is going to figure it out, you can have a fight on your hands. If you don't have parents alive, then it goes to your adult child. Well, what if you have more than one adult children and now you're having to have them kind of duke it out and figure out, well, we think, two kids think that mom should stay on a ventilator. One child is like, no, it's time to go ahead and pull the plug. So you see how quickly you can just end up creating a bigger mess between siblings or between parents. Then, okay, in the hierarchy, we'll leave it to sisters and brothers to decide if there's no parents, if there's no spouse, and there's no adult children, then your siblings have to make a decision. Again, if it's multiples, you have a situation where they may not all be on the same page. Then, if none of those are around, we look to grandparents and grandchildren. So, if it's a grandparent in the hospital and nobody else is around or alive, they will look to their adult grandchild. We'll try to have a guest on the show. We actually have a client who ended up in that position due to COVID. She was the adult grandchild and needed to make medical decisions regarding her grandfather. She had never had that type of conversation with her grandfather. She had no idea what he would want in a medical crisis. And she was forced with trying to figure out what made sense given that his age and how COVID has been. And that was a very stressful time for her. So hopefully I can get her on the show and she can go through that with y'all. I know some of y'all need to hear it multiple times. Once you hear her experience, maybe that's going to be the key for you to say, you know what, I need to get this done and I need to really get this done sooner rather than later. So like I said, this is a document you need and your parents need. Okay. Let's see what else I want to make sure y'all understand about this document. The second part, treatment preferences. This is kind of the meat of the document. So here in Georgia, the document only comes into effect and applies when there's no hope of recovery as determined by your doctor. So this is not, like I said, a willy-nilly, we just came in for hip replacement. There has to be a doctor who has written and determined that there is no hope of recovery, who has determined that you are incompetent and no longer are in a position to make healthcare decisions and to name your preferences. They have to decide that you are terminally ill, which means incurable. It's an irreversible condition that will likely end in death after a short period of time. Or you have been permanently unconscious or in a vegetative state. So this is two really grave conditions. Again, terminally ill, permanently unconscious. And a doctor has said there is no hope of recovery. And you have become now completely incompetent and unable to make your medical decisions. So under that portion of the document, you get to specify if these conditions occur, here is what I want to have happen in these conditions. I can either say, I want y'all to fight, fight, fight. I want every type of medical treatment that is available. I want you to continue to do everything that you know how to do, medical team. Or you can say, you know what? I really think that I want to let nature take its course. I want to go ahead and let things play out as they should. Or there's a third option where you can do kind of a hybrid where you say, I want you to keep me as comfortable as you can, but eventually I want nature to take its course. Under the third option, you can make some elections as to what it means to keep you comfortable. So you can say, yes, I want to be given pain medication, for example, or I want to still be hooked up to a feeding tube. So those are the types of decisions you can make under the hybrid option. So then the next part of the document is your guardian. This is if we end up having to go to court and need some type of court intervention because for whatever reason, there's a fight, there's a disagreement between siblings or parents and siblings or whoever the case may be. If you need to go to court, you can go ahead and name in the document, listen, courts, I know who I want to make the person that is going to make the decision and be the ultimate decision and tiebreaker in this situation. A lot of times, my clients just name their agent, the same person that's been their medical helper who's been making decisions up to this point. And then the final part of the document is just the signatures. And I think I talked about this at the beginning. It's just making sure that you have the two witnesses and it's signed by two people over the age of 18 who are of sound mind, and that it's not your treating physician or healthcare person. There is also in the document the ability to talk about the disposition of your remains. What's going to happen to your body and your organs in the event that you have passed away? A lot of times people think, oh, we're going to do this big funeral, we're going to have this ceremony, and you may not want that. And so this is a place to also specify whether you want to be buried, if you want to be cremated, if you want to be turned into jewelry. That is a new thing. And I've seen a lot of where people use the ashes and put it into some type of heating process so that it can be turned into a piece of wearable jewelry. You also want to make sure in that part of the document, there's questions about atomical gifts. This is gifts for transplants, therapy, or for research. Do you want your agent, your healthcare person, to be able to gift your organs for the sake of science and for the sake of helping other people? A lot of people say, well, I signed my driver's license. I already made this decision. If your hospital has no record of a decision about organ donation, they have to ask if you are willing to be a donor. And so they're going to ask your next of kin, can they donate? So if you have very strong opinions about that, make sure you fill this part of the document out. Make sure your agent knows what your feelings are. You may feel very strongly about it and don't want it. But if you don't tell anybody, think about it. Your family is under pressure. Here comes doctors asking them all these questions. They're grieving. They may not be thinking straight. So you want to make sure this is written down somewhere and that they don't have to make this kind of a decision in the middle of a crisis. So advantages of having the document. I think I've gone through some of them, but I kind of want to wrap up with this. It's kind of a roadmap. It expresses your thoughts about your feelings about life and death and what your treatments are. It's also a place for you to express any religious views you have. I would get a lot of clients who are Jehovah's Witness, for example. So their religion really dictates how they want to see some of their medical treatment. So this is a place where you can write that down and make sure that people understand and take that into consideration when they're making decisions on your behalf. And really, it's a place for you to still have control over the decision making because you've written it down. So people know what it is your wishes are. And it allows you to kind of help relieve the stress on your family because they're not having to just make these decisions off of what I think she might want or what I think he may want. And so it relieves them of the burden of trying to make these hard decisions without any type of background or context to figure out, where should we go with this? It gives your healthcare providers some guidance. It helps them to understand this is what she will want in this crisis. And I think overall, it makes for better communication because you can go into a medical crisis confident. You know what your mama want. You know what your daddy want because you've talked about it. When you have that level of confidence, you are able to really be an advocate. You're really able to listen and hear what the doctors have to say and make a decision without guilt or worry. And so you want to make sure that you have this conversation. Y'all, I can't stress this enough. I can't talk about this enough. This is one of those documents that I am always doing presentations on. I'm always talking to clients about. It's not a very difficult document in terms of how to fill it out, but it is a difficult document because people don't want to talk about it. And so if you don't talk about it and you don't put things in place, I mean, I think I've harped on it enough. You understand what the disadvantages are of not having one in place. Before I finish, let me just go over the kind of the disadvantage. It's a document, y'all. It is paper. Understand that unless you give it to your doctors and they have it on file in your parents' file, in your file, everybody on the same page, it serves no one. If you just got it locked up in your safe or you got it in the safe deposit box, nobody's going to know you have it out there. So you want to make sure that you keep it current, that you share it with your medical professionals. If you change your mind about who you've named as your agent, or if your parents change their mind, it is really easy to change the document. All you have to do is destroy the first one and do an updated version. That's it. Tell your professionals, hey, I've created a new healthcare directive. Here is a copy of it. Real simple. Does not cause a whole bunch of drama. Before I wrap up, I did want to talk about do not resuscitate orders because I get a lot of questions. These are not the same things, y'all. A do not resuscitate order has to be written by a doctor. It's not drafted by a lawyer. So your advanced healthcare directive, I can draft. Lawyers in your state, wherever you may be, they can draft that for you. Also, do not resuscitate orders may not be legal in all states. So you want to make sure you know what is the law in your state. It really kicks in when there's a feeding tube or a ventilator. And like I said, this is something your doctor has drafted. And so it's already in your file. In some states, oral statements are not legally effective. So it has to be written and it has to be in the file in order for them to even consider it. So if your parents are interested in a do not resuscitate order, they need to have a conversation with their doctors and their doctor needs to write it just like they would write a prescription for them. I think that's everything, y'all. I think I have gone on and on about this document and its importance. I hope you learned something today. If you don't feel comfortable even having a conversation with your parents, just share this episode. Like say, Mom and Daddy, I got something for you to listen to. Or just turn it on while y'all in the car. Like, hey, let's listen to this wonderful podcast I just discovered. That way they get the information too. And like I said, this is an episode that you need to take into consideration with your family as well as share with your parents so that they can have this in place. Here's another question I get all the time. Do we need an attorney to draft this document? The answer is it depends. Like most legal things, that's always the answer. But here's why. Where we are in the state of Georgia, you do not need an attorney. This document is online. Your healthcare provider may have it. You can pretty much get it anywhere. The reason I say it depends is if you have very strong opinions about how you want your medical treatment handled, and you want to make sure that it is properly documented in the documents and it's crystal clear as to what you mean, then I would say definitely seek advice from an attorney. What I have come to know in all my years of practice in law is this: words are very powerful and they can be manipulated. And so you could end up writing something down, thinking it's crystal clear, thinking everybody understands what it is you have on that paper. But somebody else, when you are not around, could see something totally different based on what it is you've written. So if you don't want that kind of confusion and you want to make sure that it is written in such a way that there is no issue and there is no confusion as to what you mean, then you absolutely should seek the advice of an attorney. Now, there are blank lines on the document that you could just handwrite something in. Again, if your handwriting is poor, if you think that it might be some type of confusion about what it is you're trying to express, or you have a very complicated situation, or you have very strong opinions about how you want your medical treatment handled, and you want to make sure that it's properly documented in the documents, make sure it is properly written in there, then get an attorney. All right, I think that's it for now. Make sure if you have any questions, you go to our Facebook group, Black Parents Aging. That's where I'll answer your questions. And make sure you subscribe so you can hear our next episode. All right, thank you. I will talk to y'all later. Bye.
Thanks for joining us this week on Black Parents Aging. Check out our Facebook group at Black Parents Aging, where we go live to answer your questions. For more info on today's topic, check out the show notes on our website, srlawgrp.com. If you know someone who could benefit from today's episode, please share a link to the show. Subscribe to the show to catch new episodes and leave a review. Until next week.